all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Justice Peter Sachs. To my right is Justice Singh. On Zoom is Justice Maureen Walsh. Will be your panel for all 5 cases this morning. If you've been to the Appeals Court, you know each side has 15 minutes. There's no rebuttal time. We have read your briefs and the record, and we know what your arguments are and the issues are, so I'd urge you to get right into the core of your argument. And with that, I'll call the first case, 23P185, Commonwealth versus Luis Ortiz. Yes.
Problem with the recording system?
Yes. Okay, we're having a problem with the recording system, so we'll just hang on for a sec. All right, whenever you're ready.
Good morning, Your Honors.
Good morning.
May it please the Court. Devin Hincapie on behalf of Mr. Ortiz. Mr. Ortiz's case is essentially about 2 fundamental constitutional rights, the right to present a defense and the right to confront the witnesses against him. And he was denied those rights by the trial judge's refusal to allow his counsel to impeach the credibility of the complainant through the best evidence that there was. Her best friend's testimony that, contrary to what the complainant testified to at trial about being asleep when Mr. Ortiz began having sex with her, she had told her best friend in the days afterwards that she thought she'd been having sex with Mr. Ortiz's cousin.
She didn't say it, as I read the transcript and the proffer of this at the sidebar, she didn't say that she wasn't asleep when this sexual activity began. She just said, according to the proffer, that she thought she was having sex, or the cousin was having sex with her. So I wasn't
Correct.
sure I saw a contradiction.
Well, it's a statement that implies both awareness and being awake.
Once she woke up, she initially thought it was him. I mean, actually, maybe you could walk us through the sidebar, because it's kind of confusing. At first,
Sure.
It looks like she is, the counsel is offering, let me just get to it here,
Sure.
Suggesting that she had actually had sexual contact with the cousin earlier in the evening, which would be inadmissible under the rape shield statute.
I didn't read it that way. I guess maybe because of the awareness of the full record that I have.
Yeah.
What he says, I'm just quoting from my brief on page 9. This is defense counsel, the offer of proof. It's not for the truth of the matter asserted. It's GM telling this court that she had sex with Mr. Ortiz that night, which is what that's what he's talking about at trial.
Well,
she's testifying that she's asleep.
At first, page 190, counsel says she told Ms. Hazel that she had sex with the cousin that night. That's lines 18 and 19.
Right, and that statement is what I am suggesting to the court implies her being aware, being awake, that she doesn't say to Ms. Hazel that she's asleep and she wakes up and she thinks it's the cousin. She's talking about, I thought I was having sex with the cousin. Well,
there are 2 different statements here. The first one is she told Ms. Hazel that she had sex with the cousin that night. Wouldn't that be inadmissible under the rape shield statute? This is not the second statement about what she thought, but I'm looking at page 190 of the transcript.
Mm-hmm.
lines 18 and 19.
So it's impeachment of her saying to this court that she had sex with Luis Ortiz and initially who she might have thought was someone else.
Well, before that, if you have the transcript in front of you, the counsel is offering something else. And then he seems to shift gears, and there's unfortunately an inaudible portion of the sidebar. And then she says she had sex with the defendant, and initially who she might have thought was someone else, and what Ms. Hazel would testify to was that the victim said she thought she was having sex with the cousin in that moment.
What I would suggest then is that it may be inartfully phrased. When I spoke with trial counsel, that was the theory of defense. That was what his investigation had uncovered. When he speaks to witnesses, when he speaks with his client, he speaks to witnesses, he's developing his defense, he understands that in the days and weeks afterwards, when Ms. Hazel and the complainant spoke on multiple occasions, as they both testified to, that Ms. Hazel said, she told me she thought she was having sex with Mr. Ortiz's cousin. And then, you know, this is not in the record, but that's his defense. And so that's what he's trying.
Is there anything she said that implied that that was consensual sex with the cousin?
I think it's implicit in the statement. I think it's implicit in the statement. And if you don't read it that way, I guess, you know, in that term, you know, I guess I'd have to agree to disagree. But I think it's implicit in the statement that she wasn't complaining about unconsensual sex with the cousin.
Because you mean in the way it was framed? You mean the language that was used had sex rather than being attacked or something? I mean, how would we infer consent versus non-consent?
Because it comes from being awake, from that implication that if you know, I thought I was having sex with his cousin. I'm awake, I'm aware, I'm thinking it's his cousin.
Yeah, I understand the awareness that's implied.
Sure. In terms of, right, she's not complaining, she wasn't saying that she hadn't consented to that contact. And that's where that comes from. I think that was the crux of his defense. It is unfortunate that give and take between defense counsel and the judge at sidebar, who also seemed at different points to be, you know, confusing what defense counsel was trying to do at any one point. There was an issue about a boyfriend and you know, perhaps, you know, prejudicial information about the boyfriend having come, and she'd be talking about that, and that was kept out, and defense counsel wasn't trying to get at that anymore at all. What he was hoping to bring in. Mm-hmm.
Could the statement still be construed as her having had sex with the cousin earlier that night, not talking about that specific moment?
Well, I don't think there's any testimony that there was any intimate contact prior to her going to bed. The only testimony and the only evidence in the record anywhere was that they were all hanging out together prior to her going to sleep. That there was no, and that when she went to sleep, the cousin was still in the dining room with Ms. Hazel and Mr. Ortiz hanging out, and she had gone to bed. So I don't think that there is any support for the idea that she was telling Ms. Hazel, you know, later on, that there had been some sort of contact before. That is the heart of her complaint. And I guess, again, the problem here, you know, as you know, besides appeals, I also do trial work, is when you're developing your defense, and this is your witness, and this is the complainant is, these cases are all about credibility. And so if the jury is not allowed to hear statements that would contradict, be inconsistent with what she's testifying to at trial, it maintains this halo of credibility around her that she's only given this one version ever. And I think that is the heart of that constitutional right to present a defense and to confront those witnesses against you, whether directly or through other witnesses' testimony.
Can I interrupt for a moment? Because I understand your legal argument in general, But based upon the facts of this case and this transcript, I'm having some difficulty understanding why the statements would be impeachment. So sure, if the defense at trial was, it was the cousin who raped her, not me, then I think that statement would be admissible of what she said to Ms. Hazel, right? And it wasn't the defense at trial. The defense at trial was this was consensual sex between the defendant and the victim.
Exactly. It totally.
And so the evidence at trial that I read and reread was she woke up in the act of being raped. So impeachment of who was the rapist, yes. I think that's something, but given the statements that were made, I don't see how that is impeachment. When, to me, I'm having a difficult time understanding how that relates to consent, given the facts of I woke up because I was being raped. Understanding, you know, your interpretation of sex versus a victim saying forcibly assaulted, raped, etc. But I'm still stuck at why that's impeachment given what we have as the backdrop in the facts.
Well, Your Honor, it is exactly, it's not, the defense is not that Mr. Ortiz's cousin raped her. That's totally not what his defense was. The defense was that she had, when the sexual contact started, it was consensual because she thought it was his cousin. When she realizes that it's Mr. Ortiz, she withdraws that consent, essentially. She jumps up. She's like, hey, what, you know, like, what's going on? And he actually stops immediately, too. And so the defense, if the defense is, it's essentially perhaps a mistaken consent, you think it's this person, but it's not, then what Ms. Hazel has to say about the complainant telling her afterwards, just explaining, what was going on, I thought I was having sex with his cousin, that's contradictory to her statement at trial saying, I was asleep when I woke up and this person was having sex with me. That's directly contradictory. And I think if you, again, it is not about consent. It's about the credibility of the complaining witness and the inability to challenge that credibility by offering testimony that she made statements that are inconsistent with her trial testimony, which was, I was asleep when this person was having sex with me. You know, that's the issue.
So if this is the core of the defense, one would think that defense counsel would have a more accurate and precise proffer of what the witness was going to say. And if she was going to say, I was awake and I consented when I thought it was the cousin, but when I realized it was the defendant, I didn't consent, he would have made that clearer instead of going through a half a page of, I was going to say that, or she's going to say that she had sex with a cousin.
Your Honor.
It's tough to, I mean, I know this is trial, but still, if it's the center of his defense.
It's district court, I would say. I'm not casting aspersions on anything. I do think, and you can see from the judge's directions throughout to both parties, that these may not be seasoned counsel that are super articulate and able to get on the record what they're trying to prove.
Right, but we don't even, you're right, but we don't even know exactly what she would have said. I mean, you're offering an interpretation under which this could be impeachment. That interpretation, there's nothing else in the representation at sidebar. And
I respect your view of that, and I understand why you say that. And I think what I'm arguing is based on, my review of the record and my development of, having spoken to trial counsel at length, having spoken to, witnesses and my client at length, that was the defense. That's how it came out when he was trying to get across what Ms. Hazell had to say. So, if there's no further questions, I'm happy to turn to the medical records issue.
Just one more
Sure.
on this issue. The Commonwealth argues that this was not impeachment by prior inconsistent statement. Are you arguing that it's impeachment in some other way, rather than strictly by prior inconsistent statement?
What I think it is under the rubric of prior inconsistent statement, whether it's, I think the language in parent is, it doesn't have to be a complete categorical explicit contradiction. It's enough if the proffered testimony taken as a whole, either by what it says or by what it omits to say, affords some indication that the fact was different from testimony the witness sought to contradict. That's the theory under which I'm arguing that this conversation with Ms. Hazell is a prior contradictory statement, inconsistent statement, under which, under our law, the trial judge does not have discretion to exclude if it bears on an essential element, which it does here, which was consent.
May I ask about the records?
Sure.
What was the relevance of the records at all?
What was the relevance of the records?
Yes.
Well, I think the Commonwealth, has a right to get their medical records in on, what she's there for treatment or this or that. The police do send her there for that specific purpose. But
there was no issue that there was sexual contact, right? So it wasn't to prove that there was.
Right. From my perspective, it just compounds the error of the first part, which is you have these records coming in that have ultimate conclusions concerning the charged crimes, which these, this court, the SJC, has said over and over and over again. That printed language crosses the line. It's a reference to culpability.
If all of the references to assault and assailant had been redacted, would you have any issue with the rest coming in?
The only other things were the nurses. There was 3 phrases from the nurses' notes. She's not capturing what the complainant is telling her. She's got 3 statements where she says presents after sexual assault. Right.
But if any mention of assault was redacted, including those.
Would I have any issue with that? No.
Yeah.
I think under the law, medical records come in, and except with those redactions, I don't think there would have been a problem. But here, it is error under any standard, prejudicial or substantial risk, because of the fact that the complainant is the only witness on this issue. Her credibility is key, and this just bolsters that.
So you don't think that the word sexual would have had to be redacted because there was no dispute about there having been sexual contact? It's just the assault and assailant and those words?
Correct.
Okay. Thank you. We'll hear from the Commonwealth.
May it please the Court, David Mark for the Commonwealth. On the first issue, there is a good deal of daylight between what the record discloses about the proffer and my sister's representation of what it means. To go back to the transcript, the defense counsel starts with a fairly extravagant claim, but I think he just misspoke. And the reason I think that is that all the evidence was that the cousin had left the apartment shortly after the victim is put to bed. So
she didn't know that.
She didn't know that, that's correct. But just in terms of what is likely, what the representation is likely to have been, my thought was he just misspoke. And he eventually lands on what the proffer is. And that is, Ms. Hazell would testify, what she would testify to was that she thought she was having sex with the cousin in that moment. My understanding of that language is the moment when she was awoken to find herself being assaulted. So there's no inconsistency here. If that's what it means, There's no inconsistency to be exploited here. That is perfectly consistent with, I awoke to find someone assaulting me. It may be the case that in her confusion as she awoke, she thought it was probably not the boyfriend of her friend, but that doesn't mean that, that this was consensual, or that there was a kind of retroactive consent because, oh, it's the cousin. Wait a minute, no, it's Mr. Ortiz. There's no reading of the proffer that gets the defendant to the contradiction she would need in order for this to be a cognizable error.
There's nothing in the proffer from which you could infer consent to the cousin?
I don't see that, Your Honor. It would be, let's put it this way, to the extent there's even ambiguity about that, it would be so easy to resolve that ambiguity. First of all, as Justice Sachs noted, a more formal proffer. If you think you're holding 4 aces, why would you not kind of raise this, at the outset? I also, disagree respectfully with my sister that this was the crux of the defense. At least as the defense went in, remember that counsel starts with, this is BS. She came on to me. That's arguably inconsistent with this idea of, I thought it was, she thought it was the cousin, and then when she realized it was me, oh, now she has a problem with that.
Well, except that she was so heavily intoxicated that, I mean, it's
right, but
consistent with
then
someone
we're
being
back to
intoxicated.
incapable of consent, right? So it doesn't help the defendant. I think the defense the defendant needs is she was awake and consenting, which is why the defense is really, as far as I can tell, tailored around the statement he in fact made and repeated in the presence of the police. So he kind of has to deal with the facts on the ground and did a good job with that, right? So what are you left with? You're left with, she was she came on to me as she knew perfectly well what this is about, and she freaked out because now she's thinking, oh, it's awkwardly I'm the boyfriend of her friend, or she has a boyfriend, and there are all these reasons why suddenly she's upset and disturbed. That's that's the defense that that the defendant was left with, because the case is very strong for the Commonwealth on the issue of consent. She immediately expressed her, in her testimony, expressed her outrage. We know for a fact that she immediately left the apartment. We know for a fact she immediately called her father. Her father testified as a compelling first complaint witness. We know she went to the emergency room. All of that is consistent with an absence of consent. So,
But it does all revolve around the victim's credibility.
it absolutely does.
That is
it
the core of the
absolutely
case.
does. There's substantial corroboration of that credibility, but absolutely. There's no DNA evidence for consent.
So the real issue is consent, not whether, or whether this was an assault. That's the
Well,
question.
it's only an assault if there's no consent.
Right.
But
right.
yes. Yes,
So
sir.
then how is it that the word assault appearing 18 times on the medical records isn't prejudicial?
Well, under Dargon, their analysis is it would be prejudicial. It is prejudicial.
Right.
The question is, what's the significance of that, and whether it requires reversal. So the first thing I would say about that, Your Honor, is with all due respect to the SJC, and I know they make an issue of the number of times in Dargon that the word assailant or assault appears, I don't see why one instance of this on a pre-printed form is different from 18. Either you recognize it's a pre-printed form or you don't. It's not like the jury would think, oh, 18 times, they used the 18 times form because they believe her so much. No, it's just a form. I mean, you recognize that or you don't. So.
Well, when we're evaluating closing arguments of the Commonwealth, don't we often look at how many times a word is repeated?
Absolutely, for a reason, right? Because there's a volitional repetition of the problem, right? There's a piling on. But here, the form doesn't pile on. It's just a form. It just has this language.
You don't think that a form that says something 18 times is more prejudicial than a form that just says it once?
No, because I think we must presume the jury is attentive And if this language occurs once on the form, it's the same. They're going to see it. It's not like they would maybe miss it if it were only once or twice, but 18 times they're going to see that.
So then why isn't once enough?
It potentially would be. It's a problem. It's an error. We've acknowledged that it's an error, but it's not an error that requires reversal. The distinction between this case and Dargon is the fact that counsel objected. So we're in a prejudicial error phlebot universe rather than a substantial risk universe as to the 18 instances, or 12, I think, in this case, of assailant and assault.
Do you agree that other objections would have been futile to the extent, I mean, I think there were...
As to that, I think absolutely, counsel is perfectly clear. And the terrible irony here is, as you note, there was a 25-page transcript of the colloquy to try and get this right. And the judge was ultimately, I think he was familiar with Dargon, but somehow managed to miss that critical portion of the language because he quotes it at points. But you know, we reduced the case becomes about whether the prejudice is sufficient, or whether you can be confident that this did not affect the result. And I submit to you that you can, for some of the reasons I've actually already touched on in arguing the first point, which is the issue here is consent, and the strength of the case is very, very strong. I would also note a couple of other things, which is this in...
Why is the case so strong? That this wasn't prejudicial? I mean, yeah, she was hysterical on the phone with her father.
Leaves promptly. I mean, all of the issue, the live issue.
Leaving promptly is just as consistent with the defense that we heard this morning, which was, oh, I realized that it was my best friend from childhood's boyfriend, and this was going to be really awkward, so I'm going to get out of here.
I don't agree with that. I absolutely, the flight in the middle of the night to call your father, that's a very different, I would say, psychological state to be in than, whoops, this is a terrible solecism on my part. By the way, Ms. Hazel, in her testimony, describes the defendant at that time as a friend with benefits, not a boyfriend, right? So apparently, and in terms of the...
But the relevance is what was in the victim's frame of mind for that defense, right?
Right.
According to the victim's frame of mind, she assumed that this was a boyfriend.
Right, and in some loose parlance, certainly was, right? I mean, they were sexual partners, so, and she apparently knew that. But I
mean, I'm having difficulty calling this a slam dunk, for lack of a better word, case, in that when you have a sexual assault that's tied into credibility and consent, and you leave it for the jury to make that determination. One side says one thing, one side says the other. In my mind, that's a difficult case for both sides. That's not a strong case for either side.
Your Honor, I respectfully disagree. I think in this instance, the actions of the complainant in leaving promptly, her state when her father encountered her, when the police encountered her, all of that speaks to her genuine shock and the consistency of the story that she told about being awakened by the assault.
If you believe her.
But there is reason to believe her. As I said, there's no DNA evidence of consent. We're always in this universe. I would say that in the Dargon case, we sort of had the same problem. I mean, granted, there was a slightly different standard of review. Not slightly, there was a different standard of review. But the issue was not about the fact that an assault had occurred, but whether it was sexual, where in that case the victim had failed to mention the sexual part of the assault. So there was arguably more reason there, and yet the court got past that.
But in this case where there was, is it accurate that there was no dispute that there was sexual contact?
Correct.
Okay. So the relevance of the medical records at all?
I think the judge could easily have decided to exclude them entirely. I'm not sure they're terribly helpful. They aren't unhelpful to the defense because they confirm that there's no force, right? There are statements of the victim no force was used, right? So, you know, in terms of the potential prejudice to him from them being in, I don't think it's very great. And there may have been reasons why he would not have been terribly unhappy about parts of the record going in, as they're at least consistent with the story.
But records, the medical records aren't per se admissible or relevant in a case like this, are they?
Correct.
Okay. They have to be shown to have some relevance in order to come in.
I mean, in the broad sense, the Dargon court makes clear that they're taking a kind of an expansive view of admissibility here, and they do go to the question of treatment, right? It makes more sense in an instance where the treatment is for an injury.
Right. I mean, what does the treatment show here? It doesn't bear
The
on whether
absence
there
of an
was-
injury in some sense, yeah.
Well, if the defendant wanted them in to show absence of an injury, if that was actually in dispute, then I could see them coming in.
Right. I'm not suggesting that he does. I'm suggesting that as to that point, there isn't a great deal of prejudice to be had, given the nature of what was actually in the records.
So the briefs distinguish between the preprinted form and the 3 statements of the sane examiner.
Yes.
What about those?
Well, I would
How do
make
we
the same
evaluate?
argument. I have a slightly more favorable standard of review because they weren't objected to. So that's under the substantial risk analysis. But essentially the same points apply. It's really about the strength of our case, the extent to which the records are not terrifically prejudicial. But yeah, absolutely, this is a concerning issue. And as I say, vexing because everyone was trying to get this right. You know, and a good deal of these records, as you know, was excluded. There was an entire page that just went out. But
Perhaps all of it should have gone out.
I don't disagree, Your Honor. I'm not sure they were terribly probative. But I don't think their having gone in this case requires reversal. Thank you, Your Honor.
Thank you. Thank you both. Our next case will be 23P559, Commonwealth versus Timothy Hurley.
Good morning, Your Honors. Arne Hansen for the Commonwealth. This is an appeal from a motion to suppress a motor vehicle stop from the Hingham District Court. The motion judge in the Hingham District Court allowed the motion, and we are asking this court to overturn that decision. The Commonwealth principally takes issues with 2 decisions within the decision. Specifically, that the judge stated that the caller was unidentified. Now, this is both a mistake of fact as well as a mistake of law. In this case, the caller did identify himself by first name as well as the street that he lived on, so he was not fully anonymous. And the mistake of law is that the test is not whether the person is anonymous, it's whether they are readily identifiable. So I will develop that as we go further down. And the second portion, the second mistake, is a mistake of law that the motion judge makes. She appears to rely on the fact that the officers never observed any criminal activity prior to initiating the stop. And again, that is not the test. The test is whether the caller observed the criminal activity. And if we review the case law, as we'll discuss further, there are many cases that support that a stop can be based on information purely within the police broadcast that is being relayed from a 911 caller when the officers see no criminal activity themselves.
Well, what was the criminal activity that was observed by the caller specifically?
In this case, there was negligent operation. The caller stated that he was almost struck by the defendant's motor vehicle, and then there was also disturbing the peace where the caller claimed that the defendant was making a lot of noise at around 1 a.m. in the morning. Now, before we dive into these issues, I'd like to give a brief overview of the legal landscape. Now, certainly a stop based on information within a police broadcast is certainly allowed. The officers don't have to see criminal activity to pull over a motor vehicle. In order to do so, there is a two-pronged test. One, there must be a particular, the vehicle in question needs to be described with sufficient particularity. And then the second prong is indicia of reliability, which is the Aguilar-Spinelli test. Now, briefly, I don't believe that the particularity of the vehicle description is in question here. I don't believe that was part of Judge Bradley's decision, but I'll just go over it quickly. So the car needs to be described with sufficient. So here the driver gave a license plate. The officers used the license plate, dispatch used the license plate to get a description of the car. They knew that the defendant's car was in fact the car in question.
And he at least purports to be reporting firsthand observations. So that part of Aguilar-Spinelli would be satisfied, the basis of knowledge.
Correct. Now, yes.
The main dispute here about veracity?
Correct. Now, with respect to veracity, there's three ways that the Commonwealth could prove veracity in circumstances like this. The first is the caller places their anonymity at risk. The second is an excited utterance by that caller, and the third is independent police corroboration. Now, Judge Bradley's decision really focuses on whether or not the caller placed their anonymity at risk, which was the first prong where she stated caller was unidentified. Again, that's not the test here. And then the independent police corroboration, Judge Bradley focused on whether or not the officers saw criminal activity, and really the test is on independent corroboration is whether or not they find that vehicle in that location as described by the caller.
Doesn't the corroboration have to be of something other than innocent and readily observable details, like the car is on the street, here's what its license plate number is?
Yes, that's a fair assessment of it, but if we look at the case law in that case, if we look at Westgate, which is a case that I cite, this is an OUI case where you have the 911 caller behind a car that they believe is the driver's under the influence. They see it swerving, they see it almost strike a telephone pole. They're on the phone with the dispatcher. The officer is aware of the situation, gets on the road, gets behind that car, sees that car make 2 lane changes, but sees no other traffic infractions, no erratic operation, pulls over that car, and that stop was justified. Again, the officer only sees innocent driving. There's nothing about the way that that person was driving that was suggested that they were under the influence other than what came in through the 911 call. And if we look at another case, Perez, that was a shooting that happens late at night. That motor vehicle is seen leaving the scene. They find that motor vehicle a few blocks away. They pull that car over. They don't see anything. All they have is a description of the vehicle that it's either dark blue or dark green and a location, direction of travel. That stop, again, was justified. The officer's observations were, in fact, innocent.
But what if the observations not only, what if we're not talking about corroborating innocent sort of observations, but what if the observations contradict what the reporter is reporting? For example, if this is a noise complaint and the officers get to the scene and there's no evidence of any noise, doesn't the sort of the natural credibility of somebody putting their anonymity at risk, isn't that washed away by contradictory observations of the police?
Now, with respect to whether or not the officer was or the car was making noise when they found it there parked at 16 Berkshire, I would say that, again, it's not whether or not it's criminal activity that is being readily witnessed by the officers. It's whether or not there was previously criminal activity. So the reasonable suspicion standard is that there's ongoing criminal activity, past criminal activity, or suspected criminal activity. So it doesn't necessarily have to be ongoing at that point when the officer stops the car.
But the calculus here, we're looking to see whether this anonymous tipster, I'm not sure that the case law has been developed to your fine-tuned, semi-anonymous reporter, but that prong is really looking toward when officers approach, is the person calling telling the truth, right? Is this information something that we can rely upon? And so don't we look at the whole? In other words, if the caller calls hypothetically 100 times and 99 times gives wrong information and 1 time gives right, like a broken clock, don't we look at the whole and say, now, not reliable because 99 times the caller proved to be unreliable? I mean, so in this instance, at least from one officer's perspective, according to the record, the caller's information was not reliable. It seems the judge relied heavily upon that opinion. But don't we look at the whole to say, okay, in the universe of information, was there enough on one side versus the other to say reasonable suspicion level, reliability has been met?
I think that's certainly a fair assessment, and if we look at the facts of this case, the first call comes in and it's concerns about what's happening at the brewery. The officers go there and they find a defendant there and they clear the scene. And then there's the second call at the train station. The officers go there and in fact turns out that the defendant was at that location, and again, that is corroborated. And then the third call, again, the caller says this person is at this place and this time. The officers go there and it is again corroborated. So I do think that this is a case where on every single call, the information portrayed was accurate. The officers just didn't catch the defendant during the commission of the reported crime, which is perfectly appropriate given the case law in Massachusetts.
Was it appropriate for the judge to rely on officers' opinions about the credibility of the caller?
So that's with respect to Officer Gibbons, who seemed to question whether or not the second portion happened, the negligent operation, because he was located at the train station and he didn't witness that himself. And he didn't believe that, he did observe the defendant there and didn't see any criminal wrongdoing. But I don't think his testimony is dispositive of the issue because, as far as I understand it, he is the third officer to arrive at the final stop where the gun is found. And certainly it's Sergeant McLaughlin's prerogative to then initiate the stop. He did not, despite what Officer Gibbons may have said over the radio, he didn't have a reason not to stop that car. He believed that there was certainly something there that should have been investigated.
So you're saying Officer Gibbons wasn't actually, he didn't arrive at the scene of the stop until the stop had occurred?
That is my understanding, that he was the third officer on scene, if not the second, but it's my understanding that, if memory serves correctly, that Sergeant McLaughlin gets there first, Officer Arsenault gets there shortly after, and Gibbons is the third one there, and he parks behind everyone. And when he arrives, if memory serves me correctly, and I could be misspeaking, I would rather rely on the facts in the brief, so I apologize if I'm wrong, but it's my understanding when Gibbons arrives, they've already discovered that there's drug paraphernalia in the car.
But it appears from reading the decision by the judge that she relied upon the opinion of Officer Gibbons at that second MBTA stop to say, hey, there's something wrong with this caller. This isn't making sense. I've been here and what he's reporting isn't accurate. And so in the judge's analysis of whether the second prong of Aguilar Spinelli has been met, she relies, it appears, whole cloth upon Officer Gibbons kind of shrugging his shoulders saying, something's not right here. Is that error?
Yes, because again, the officer's testimony is not really dispositive of the issue. And when they initiate the last stop, it is for the noise complaint, and they find the car there at the location where it is reported to be making noise. And as I stated previously, it doesn't matter that they don't witness the criminal activity as it's ongoing, as long as there's reliability within the call. And in this case, it's established by the fact that the caller has identified himself by first name and his street address. We don't have his full name, and he doesn't stay to give his full biographical information, but if we look at the Rodriguez case, we have a cab driver that calls, says, I was almost struck by this car, the court found that it wouldn't have taken that much effort to find out who that person was. Now, in this case, if they really wanted, if they were going to investigate the noise complaint, they certainly could have found out which Maddie lived on Jenkins Place. But what happened here is a noise complaint turned into a firearms investigation, and I think a firearms case, carrying a firearm is an 18-month min-man. Disturbing the peace is a fine at best. So I think when they find the gun, I suspect the officers really just forgot about the noise complaint and we're dealing with a much more serious case.
You had said there were three factors that bear on veracity, whether his anonymity was at risk, the caller's, whether police corroborated details, and the third was?
Excited utterance. So excited utterance deals with, whether the report is being made in real time, and that appears to be the case from the record here. Unfortunately, we don't have a recording of the call anymore. The Commonwealth copy was given to the court, and when the record was reassembled, they could not find that anymore.
Was this ever argued to the judge that this was an excited utterance and was credible for that reason?
If memory serves me correctly, I don't believe so. But that is certainly something that this court can consider, but I don't believe it's something that can be fully developed where we're not in a position to actually evaluate how the message was conversed and whether, in fact, it was an excited utterance.
And given the lack of the call, it would be futile, wouldn't it?
Correct.
Even if we were interested in developing that, it can't be developed now.
Correct.
So Matty from Jenkins Place calls and says the car is now on Berkshire Road and it's waking up his family. So if he's with his family on Jenkins Place so that he knows they're being woken up, how can he know the car is on Berkshire Road? And conversely, if he can see the car on Berkshire Road, how does he know that his family is being woken up?
My understanding is those streets are adjoining, so I think they're geographically very close to each other. Again, the caller reported this car is in this location. And then the officers go there and find that car in that location.
Does it matter that Matty never showed up at the station?
No, because again, the test is whether or not he's readily identifiable, not whether he's going to be identified. And it goes back to if they wanted to investigate who this person was, they certainly could have. But again, they found a gun, and I'm speculating, but I think that took over the investigation. I think the disturbing the peace investigation went away when they found the gun. Thank you. All right.
Thank you. Mr. Frades?
May it please the court, Attorney Michael Freites for Timothy Hurley. Judge, what you have here is a question about the veracity of an unidentified phone call that prompted police to stop Mr. Hurley on 3 separate occasions. On the first matter, it's worth noting that police stopped the gentleman. He was not intoxicated. They found no evidence that would suggest any kind of noise disturbance. The gentleman said the car is malingering. The officer said there's no law being broken here, and the caller never really asserted there was. On the second stop, he says he was almost hit. Notably, there was no evidence that that information was communicated to any police officer. It is on the 911 call. But Mr. Arsenal says there is no allegation through the tip that any illegal activity or infractions actually ever took place, and no officer says otherwise. I think that's significant.
Right, so you're saying that the officers were not aware of the report that the defendant had, or that the caller had almost been hit?
Exactly, Judge. It's on the 911 call, but no officer says anything about it. In fact, Officer Arsenal specifically says no allegation of wrongdoing or infraction was ever communicated to him.
And can that be imputed in some kind of horizontal, what do we call it,
Yeah, I'm familiar,
officer
Judge.
rule, but the Privet case?
I think not, only because that's when one police officer has that information, and a recent case came out from the SJC that suggested those police officers have to be involved in the same organization, investigation. Here, we don't know what the dispatcher interpreted that call to be. I think we would have to assume that the interpreter, the dispatcher did receive that information, she would have passed it along to the police. But for Mr. Arsenal, Officer Arsenal, to specifically say no allegation was communicated to him, I think that speaks to the issue. Also, Judge, so the first thing he says, this car is malingering. And there's no indication. The second call, officer says, it's more significant than Judge Walsh mentioned earlier. The officer said he could not see this from his vantage point. How could he see this? So I think that speaks directly to credibility. However, it's past midnight in this suburban area. And on the one hand, we have a caller says, there's a car lingering in the area. Then that's 12:05. At 12:55, he's on the street with his mother, who almost got hit. And then later on at
Or possibly in a car, it's not clear.
Sure. And then 1:25, now he's home. And when they make allegations of a noise dispute, nothing's corroborated, but is there a muffler problem? Is there a radio problem? Some of this information could have been corroborated by the police if they could have been horsing around in the parking lot. But to simply stop somebody and they are cooperative, no signs of drug or alcohol, is a car simply driving down the street at a reasonable speed to be assumed? Is that even disturbing any piece? Also, if in the third call, where he does claim that there's a disturbance, like the court pointed out earlier, it doesn't necessarily on his street. And the police, it would have been helpful for the police to know exactly what the caller's vantage point was, but he's not telling the police. They don't have his name. He gives their name later. The police say, would you like to talk to us? And he doesn't. He says, no, I'll come by, and then never comes by. I interpret that as him actively trying to conceal his identity. When you take the idea that he's in his house, now he's on the street with his mother, now he's back in his house, the police opinion, he could not possibly see this from his vantage point.
Did the officers know that the caller had identified himself as Maddie on Jenkins Place?
That's a good question.
And is that relevant? Does all of the information about veracity have to be communicated to the officers, or is it enough that it was reported to the dispatcher?
I don't think that Maddie on Jenkins case amounts to anything. Even if they wanted to, I don't think it amounts to anything. Even if they wanted to find Maddie on Jenkins Place, are they going to run every address on Jenkins Place?
At least he purports, I mean, Jenkins Place from the map in the appendix doesn't look very long. Wouldn't seem very difficult in a relatively small town to say, is there someone named Maddie on Jenkins Place? But so he at least purported to be putting his anonymity somewhat at risk.
Sure.
Does it matter if that's communicated to the officers or if it's only known to the dispatcher?
I think it matters to I think what matters is what that officer knew when he pulled that car over. Also, Judge, when he reports the police, the Commonwealth cites Commonwealth versus Maha. In that case, description of the plate, description of the car, make, model, description of the individuals in the car. The only thing this person provided to the police was a plate number. Everything else was established by police afterwards. So that suggests that there's not any particularity here at all. Nothing was corroborated after the fact, and I would respectfully suggest to the court.
Well, the plate number is the most precise way to identify a particular vehicle. So, I mean, I'm not sure that it amounts to much that they didn't give all the other particulars once you have a plate.
I accept that, Judge. Okay. There is case law that suggests that having the identifying a person in place, the car and the place they are, is insufficient. There's no other description that would suggest. I think what's going on here is that when Officer Edward Gibbons says this man couldn't see what he's seeing, that's really that goes to reliability, but it's also basis of knowledge as well.
No, but isn't that the judge's ultimate call? Is it appropriate for a judge to rely on a witness's determination of someone else's credibility?
That's a police officer's determination, not just anybody's. That's a trained police officer.
Police officer is still a witness. We don't allow witnesses at trial to give opinions on other people's credibility.
No, Judge,
because
but
they're
we-
police officers.
Absolutely, Judge, but we do allow police officers to testify to their training and experience. And here, we have a trained and competent police officer who says, how could he see this from this vantage point? They're trained in order to assess these things, would be my argument to the court.
So it's relevant to the, whether there was reason to believe, but not dispositive.
Absolutely. And the fact that we have 3 different incidences here, the one that really counts is the last one, when the lights went on and a stop took place in the constitutional sense. And when the previous 2 were investigated and dispelled by the police, I think that matters to the credibility of the caller in the last one. Here we have allegations being made. There's inconsistencies. The Officer Gibbons is specifically saying this person couldn't see what they saw from his vantage point. We have a gentleman who, past midnight on a weeknight, is one out on the road who can see this individual. Says there's a car malingering in the parking lot of this brewery. Later on, during this work week, he says he's out with his mother in their car, and then later on he says, well, he's at home. It stretches credibility. And
Yeah, but I'm not sure that we can take that position, because if I followed that analysis to its logical point, then I would say that if I were driving a car and I saw a car swerve all over the road, and I thought the responsible thing was to call 911 and give a license plate and say, I'm not sure if this person is driving under the influence, and the police come and pull the person over, and in fact, they're suffering a medical condition, or they're texting while driving, it doesn't mean that my observations weren't accurate, that they weren't corroborated, they weren't true. It just means that the ultimate charging didn't occur. You see what I'm saying? It's about, the focus isn't about whether probable cause to arrest and it happened. The focus is on, is this person giving the information that's reliable? And we look at that because the police officer didn't see it. We say, what type of information did the police corroborate? And there's corroboration here. You may not like it, but there is.
Well, Judge, the first stop was investigated. He said there was somebody under the influence of drugs. He's driving erratically. They arrived, they dispelled the notion. There is no evidence of alcohol intoxication, no of drug use. He's properly licensed. He's properly registered. It's his family's car. So that's one down. Number 2, the second stop, he claims that there is an incident here. He's on the road. He almost got hit. Officer Gibbons is questioning how he could possibly see these events from his vantage point. And there's also a moment where he's at the MBTA station and an officer just happens by and says, this man's not committing any crime. So I agree with you, Judge, but when you have, it's unusual that we have 2 prior instances with the same person, and both those instances are dispelled, which I think speaks to the credibility of the third one.
None of the officers ever expressed any suspicion that the caller was just trying to get the driver of the car in trouble or the occupants of the car in trouble.
That would be a conclusion. But what we have is, how could he see this from that area? That's not a matter of degree. That's saying yes or no. Either he could or he couldn't, and the police officer is calling into question.
But do the times match up?
What do you mean?
From when the officer was there observing at the MBTA station and saying, I don't see anything here, how could he see that a car was here from where he purported to be? Is the time that the officer said, I don't see anybody, the same time as the caller was saying he did see somebody?
About 10 to 15 minutes later. So,
Well, a car, 10 or 15 minutes, I mean, can move.
and it did. The officers I don't think that was a stop in the constitutional sense, but the officer rolled up on the gentleman in the MBTA parking lot, and he had his conversation with him. And when the second call came in, another officer responded and was told by a previous officer that I had just spoke to this gentleman, he's no longer there, and there was no vehicle there. But I don't believe that was the result of a call. The second call is the allegation of the negligent operation. And to me, one, you have two things going together here that create a lot of suspicion regarding this gentleman's credibility. One, he's not on the road. He sees something from his house. He sees a disturbance. He calls the police. There's a car malingering. That's 12:05 on a weeknight, past midnight in the morning. Suddenly, at 12:55, he's out on the street with his mother. Now, at 1:25, he's back in his house. Is it logically impossible? No. But there's a credibility issue here. He's assigning criminal wrongdoing to this car, and you have to ask yourself, is this in good faith? I really do think that this comes down, if somebody decided, this gentleman here knew somebody, Mr. Toomey, who lived in this area, it is not outside of the realm of possibility that this gentleman who's making these calls is specifically targeting this car. Because it's hard to get around those level of inconsistencies without approaching bad faith.
Well, if someone is causing problems in your neighborhood and you think that they're going to get away with it because the police can't get there in time, so you get in your car, you try to follow them so you can continue to help the police locate this person. I mean, that's not necessarily, I mean, that's equally plausible, not that they had something in it for this.
The first car was simply that he was malingering. And then on the basis of that, apparently he got in his car, put his mother in the car at 12:55 in the morning, and went out to investigate when his claim is that he's just trying to get to sleep. A phone call to the police may have been appropriate, but to throw your mother in a car and then drive around to see if you could find this
You don't
gentleman.
know, maybe he was picking her up from work.
Perhaps.
I don't think the record really tells us much about that.
No, Judge.
All right, unless there are further questions from the panel, we'll take it under advisement. We're going to take a 5 to 7 minute break now, and then we'll be back for the remaining cases.
Thank you.
All right, please. Court is now in recess.
Hello, Attorney Carter. This is Matthias. We have a little 5-minute break, but I just wanted to let you know when we're recording, the video feed pauses. The light is staying solid blue, but like 5, 8 minutes through the video, it will just go frozen. I don't know if it's being reflected on the YouTube.
Court is now in session. Please be seated.
All right, that recess was a little longer than 5 to 7 minutes. We apologize, but we are ready for our third case, which is 23P 859 Brewer versus Anthony.
Good morning, Your Honor. It's a pleasure to be before the court. This case involves an equity complaint that was filed with the probate court to fulfill Natalie McKenzie, the decedent's wishes, that was put into a durable power of attorney special instruction. And that case was dismissed because my brother submitted a judgment from the housing court for eviction and also submitted random documents from South Shore Elderly Services. We moved to strike those documents. One, it was irrelevant, and the other documents from South Shore Elderly Services violated the Constitution and the the department's regulations. The court granted the motion to dismiss, denied the motion for expungement summarily, and so we're here because the case turns upon the...
Wasn't it converted into summary judgment?
I'm sorry?
Was this converted to summary judgment?
It was converted to summary judgment based upon the documents that were submitted. And so the documents that were submitted were the eviction judgment from the housing court. And that's what the case actually turns on, is that case. When there's a...
Correct me if I'm wrong, counsel, but when reading the decision by the judge, it didn't appear that there was any reliance upon the documents that you were requesting to be expunged, either that they were not part of the record or that they violated your client's constitutional rights, but the basis of the decision, one, rested as a matter of law about power of attorney and when that ends. And I take it you agree with that analysis, correct?
Well, the portion of the judge's ruling does refer to her capacity, questionable capacity. So in order for the judge to actually, include that in her decision, she relied on something, which was what my brother submitted.
So let me back up for a moment. You agree with the judge's interpretation of case law that power of attorney ends with the death, in this case, of Natalia, right?
Ms. McKenzie, yes.
McKenzie. Okay, so the second issue that the motion for summary judgment as a matter of law was granted was because it was undisputed that your client signed a general release. So if I look at the decision and I don't look at the elder abuse or anything else, and I look at if an individual signs a general release of liability, whether that bars a suit in equity. Can you address why the judge got that wrong?
Because as a housing court, we have to look at where it was signed. It was signed in the housing court, which had limited jurisdiction, which my brother acknowledged. And the language in that eviction judgment is meant to deal with tenancy in the housing court, not to deal with case matters outside. My brother acknowledged during oral arguments, which is in the transcript, that it was never discussed, the equity complaint. The equity complaint deals with the care and companionship that Mr. Brewer provided the decedent during her lifetime.
But the release wasn't, the release language wasn't limited to claims or counterclaims in this matter or any claims that could have been asserted in the housing court. It was any claims.
But we have, for my viewpoint, we have to look at the scope of the housing court. The housing court doesn't deal with matters as to equitable distribution or equitable, in essence, testimony disposition.
Can I back up for a moment? I'm having difficulty accepting that argument. You go into a gym and you sign a general release, right? That no matter what happens, you fall and hurt yourself in equipment, et cetera, you're not going to hold the Planet Fitness or some other entity responsible. Now, if the claims are under $50,000, you would attempt to file a suit in the district court. If they were over, you would go to Superior Court. But it's not the court that limits your ability to proceed. It's the agreement. Do you see what I'm saying? I'm looking at the language of the agreement, not which court it ends up in.
But
Why is that not the accurate view?
We're looking at when there's an agreement such as this, the material facts are not in dispute. This case that the eviction was signed in, it was started by a conservator to evict somebody. The eviction is the purpose of this case. There was no other claims that were relating to the eviction. The material facts is also that my brother acknowledged that there was no discussion about the equity complaint as well. So this is a question of law as to the interpretation as to where it was signed, and there's ambiguity as to any and all claims when the subject matter of this case involves the eviction and the subject matter of the equity complaint involves a completely different case.
Did, in opposing summary judgment, did your client file any affidavit saying, this is what I understood the release language in the agreement for judgment to mean, and I never thought it affected the equity complaint?
He didn't file anything because my brother had already acknowledged during oral arguments that the discussion was never about the equity complaint.
But isn't the important thing what your, well, conceivably could be important is regardless of what the discussion was, what did your client think he was releasing?
But that turns upon the intent, and this intent of the agreement is as acknowledged by my brother, that issue was never discussed.
Okay, so is there a genuine issue of material fact about what the intent was?
Well, when there's ambiguity, then the ambiguity would turn upon the appellant's favor. So in this case, there's ambiguity when an issue has not been discussed, as acknowledged by my brother, and when such things is acknowledged, it makes that ambiguity. In essence, that it clarified the circumstance that my client was in. He went in there to be evicted. He signed something so he didn't have to deal with the use and occupancy that he would have to incur in housing court. There was no discussion about property ownership because landlords can bring evictions and title still is not in dispute. In this case, a conservator brought the eviction, so ownership is still not in dispute. And the statute that governs the housing court specifically states that any judgment that's issued in housing court does not affect title. And so the ambiguity...
But it's the agreement, counsel. I mean, we keep going to that. I mean, we're basing our review upon a judge's interpretation of contract law, that your client was represented by counsel, that the defenses to this type of agreement being enforceable were not raised, like duress, like coercion, like mutual mistake, right? And that although the language could have been clearer, that since none of those defenses were raised, that generally, as a principle, we allow general releases to be given full force and effect.
But we're characterizing...
And so I disagree, and I urge you to focus your argument outside of the jurisdictional limits of the housing court, because I think if there was an example where in the agreement, it just so happened that there was an automobile accident with an eviction, and there was an agreement with counsel to dismiss a bunch of things, and it was made without duress and coercion, without mutual mistake, it could be entered into a valid binding agreement, regardless of the court that was sitting and accepted the agreement.
Then we look at the nature of the personal representative's rights at that time. In the Massachusetts, real estate goes to the legacies at this point, or the device, or goes to the family in which it's supposed to go to. In this sense, second cousins, distant cousins. The real estate, there was never a license to sell. So that interest, how could he have authority over an interest in which the person represented had no
assuming
interest?
you're right about that, nevertheless, your client chose to sue the personal representative. The release applied to all claims against the personal representative. Maybe the claim regarding the real estate, maybe this equity claim is not going to solve anything, because maybe the claim is really against the heirs at law. But still, the question is, does the release bar this suit, whether this suit is meritorious or not?
The release is not part of the suit in my view. The claim procedure for probate, in order for a creditor to file a suit, they need to file a claim against a personal representative. That puts the legacies in notice that there's a claim upon the property. If they did not file that claim within a 1-year time period, that real estate would not have any effect. That's what the license sale statute states. It has to be filed within that 1-year time period in order to hold that real estate. And that's what we did. Now, if we succeed on that claim, they can't sell it. That's in essence what we're trying to do. Establish a claim, notice the claim. The license sale time period is now past a year, so if this case goes back, we would now have to bring them in because they are the rightful owners of that property. But it doesn't bar it because we filed against a personal representative because he had an interest on the personal estate.
So if we were to affirm the judgment here, would you still be free to bring an action against the heirs?
That's a question that I'm probably going to have to look at, but it's the real estate would be, the claim against the state would still be there. We still would need that in order for the beneficiaries to be held accountable. So
you need a live claim. It's not just a question of notice.
It's not. It's a live claim that brings that case forward. That notice that we filed in that 1-year time period has not put a hold on that real estate. By dismissing it, you in essence are permitting the beneficiaries to now move forward with selling the real estate. I think the only interest that the personal representative had at that point was to personal property such as rent. And that's what my client was focused on. If he stayed in the property, he would have to be accountable for use and occupancy. And that's what he focused on. As acknowledged by my brother, no issue concerning the title was ever discussed. The equity claim was never discussed.
I'm still confused then. Why are we here if your argument now in the alternative is that this is the wrong person. This personal representative is only for rents and things of that. It's the heirs, it's the second cousins who never knew this decedent, who are the right parties. Then what does it matter?
Because the claim procedure requires it to be filed against a personal representative in order to put notice upon this Chapter 190B, Section 3-804.
You're saying that the personal representative was only for rents and collection of rents.
And it also puts the state on notice by filing a claim against a personal representative. So
why didn't you file against the estate and the individuals who were the second cousins?
Because during that time period, the personal representative can still file, because a personal representative can obtain a license to sell. By obtaining a license.
Okay, so then they're more than just collecting rent individuals.
I'm sorry, Your Honor?
They have more authority than just what you just said, which was all they're there for is to collect rents. And when I went in there, that's all it was focused on. And whether that's in your client's mind or not, it seems to be irrelevant. But beyond that, it seems as if the personal representative had the authority to sell the property, right? At that time. That's why you initiated a suit in equity against them to prevent this and to get your client to get the house for $1,000, right?
At that 1-year time period, it had to be filed against a personal representative.
Right. Okay. Thank you.
May I ask a question about the expungement issue? You cite in your brief Chapter 19A, Section 23B, which I believe speaks to the obligations of the Department of Elder Affairs. And that talks about if the department can't substantiate allegations in a report of elder abuse within 3 years, it shall destroy said report and any other records. So your expungement argument seems to be directed against this state agency, not the court.
Again,
missing something?
These were confidential documents that was submitted to the court. The court's ancillary jurisdiction is to handle those sort of information that should not be part of the court's document.
Well, the court has impounded them, but where does the court get authority to expunge them? I mean, the court, SJC has been pretty clear that expungement is kind of an extraordinary remedy and is almost never going to be implied. It's got to be explicit in the statute. You may have a right to have the Department of Elder Affairs destroy these records, but I don't see where that's a claim against the court.
I think the police commissioner, police commissioner of Boston versus the Municipal Court of Dorchester does permit the court to grant expungement. In that case, they didn't.
Was a fraud on the court case?
No, it wasn't. It was a juvenile that the case was completely irrelevant. I mean, not relevant. It was again like this, not substantiated. When a case is not substantiated, there has to be a mechanism in order to fulfill the 14th Amendment, and the court's authority to enforce to regulate itself is what gives it the authority to expunge.
Okay, so if you're talking about the 14th Amendment, then we're looking at a liberty or property interest. I think you might have mentioned Paul v. Davis.
Yes.
How have you been deprived of a liberty or property interest, or how has your client been deprived if the records are now impounded in the court versus expunged?
Well, the court in Police Commissioner of Boston versus Dorchester clearly defined the difference between expungement, sealing, and in this case, was it impounding. Expungement is the complete removal of its existence, and sealing is keeping it away from the public. It's the same with impounding, it's keeping it away from the public. So the right to expungement that was granted by the legislature by regulating the elderly services gives Mr. Brewer that property right that he has because it impacts him. That's what the statute was meant for, is to protect elderly people from these allegations in the circumstance. There were two elderly people living together and people questioning their living arrangement. So,
if there's a claim of expungement, the only entity that has the ability to expunge in this instance would be the elderly services. So unlike the cases that you cited in which the judiciary has control over records, over criminal history board, etc., this is not that. So a judge doesn't have the inherent authority to expunge another entity's. They can order it, but by law, it's the entity itself. If after 3 years it has not been substantiated. So you may have a claim against elder services. I just don't see how that then creates anything, especially where the judge didn't rely upon it. It was a decision as a matter of law.
again, it was submitted from my brother to the courts. It's in the court's records. The court can't deny that it has authority to control what goes into its records. And by having the legislature's authority to expunge, there has to be some sort of hearing mechanism that allows expungement. There is none. Not in the courts, not even in elderly services departments. So there has to be a procedure.
All right. We've got your argument. Thank you very much. We'll hear from the appellee now. Mr. Flavin.
Thank you, Your Honor. If it may please the court. Good morning, Your Honors. Paul Flavin on behalf of Chester E. Anthony as personal representative of the estate of Natalie McKenzie. I consider it a fairly simple matter, Your Honor, that's getting kind of out of hand. My brother's kind of confusing res judicata with an agreement between private parties that included a judgment in the housing court. I would agree with my brother if the housing court had entered a judgment ordering the eviction and giving possession to my client, period. I couldn't use that to collaterally stop this claim. But that isn't what happened. This is an agreement for judgment. Within that agreement for judgment, the parties agreed that a judgment for possession would enter. They agreed to other things, such as Mr. Brewer would release any and all claims against the estate. Now, what's been brought up is the issue of the equity complaint and the subject matter that hadn't been brought up to me or to my client. We didn't know about it. So therefore, it couldn't have been included in the release. I couldn't disagree more. It isn't what I knew. It's what Mr. Brewer knew. Mr. Brewer knew about this claim throughout the eviction, throughout the negotiations to resolve the eviction, and never brought it up once. But knowing that, he signed a release with the assistance of counsel. Counsel even signed the release. At that point, Mr. Brewer, with the knowledge that he has this claim, is agreeing in an agreement for judgment that he'll release all claims against the estate. There's been some argument that, excuse me, Mr. Anthony, as personal representative, didn't have title to the property. Again, that's a red herring. I believe the law is that upon the death of Miss McKenzie, the fee title, the legal title, vested in the heirs at law. But record title does not. Record title is still in the name of Miss McKenzie, and upon her death, when there's a personal representative appointed, that person becomes in charge of that property. Does the personal representative have legal title? No. But they are in charge of that property because record title and ownership at the time of her death was in Miss McKenzie. In order for the personal representative to convey that legal title, certain things are necessary, such as the assent of all the heirs at law. And once you have all the assent of heirs at law and you find a buyer, you petition for a license to sell from the probate court and get permission based upon the fact that you have the heirs at law assent to it. That gives the personal representative the authority then to convey legal title. The proper party here for Mr. Brewer to bring the action against he doesn't have a claim against the heirs at law. The contract, the power of attorney, alleged agreement between Miss McKenzie and Mr. Brewer that upon her death he could buy the house or receive the house for $1,000 is not between Mr. Brewer and the heirs, so he wouldn't have a breach of contract claim against the heirs. The claim would have to be brought against the estate, handled by the personal representative. That's what was done. Unfortunately, Mr. Brewer voluntarily entered into a release that is not ambiguous, and I agree with the court. Could it have been tightened up a little? I guess, but that's Mr. Brewer's from his perspective. From my perspective, it's crystal clear. He releases any and all claims against the estate. Now, at the time, I was concerned not about complaints in equity for testamentary transfers contained in powers of attorney. I was concerned with the potential claim, despite the substantiated allegations of financial abuse, exploitation. I was concerned about a claim for care and maintenance brought against the estate. So I wanted to relieve that. And following up with Justice Walsh's example, I had thought a little different, Your Honor. I said, if in the agreement for judgment, we got permission, possession of the premises, we waive any use and occupancy, and I agreed on behalf of the estate to pay Mr. Brewer $5,000 for having drove Miss McKenzie back and forth to doctor's appointments. Would that be unenforceable afterwards? If I refused to pay the $5,000, and Mr. Brewer said, hey, I have an agreement for judgment we all signed with lawyers, I was to get $5,000. Could I then say, that's not within the jurisdiction of the housing court? They couldn't order that, so you can't have it in an agreement for judgment. Of course you can. This is an agreement, a contract between parties. The fact that they agree that a judgment for possession in the eviction proceeding will enter as a result of the agreement for judgment doesn't restrict the other agreements that the parties freely agreed to in that release.
So the initial summary judgment decision was based on the release. Then there was a motion to reconsider, and in the reconsideration decision, the judge relied not only on the release, but also on some res judicata effect from the agreement for judgment. And that was appealed. There was an appeal from the denial of the motion to reconsider. So what do we do with that? Do we just say whether or not that was right? Because the appellant does have an argument under Chapter 239, Section 7. We say whether or not that res judicata point was right, the release was a sufficient basis for the judgment?
Well, first of all, Your Honor, I would suggest to the court that it's not res judicata. The matter wasn't fully litigated. It was released. So whether or not the judge opines on res judicata, it's very clear from her written decision that it's based upon the release between the parties. And the courts always give very, very strong weight to the agreed-upon resolution of disputes. And this is clearly what's happened here. But I agree with the court. It's not res judicata because the matter wasn't fully litigated. It wasn't tried. So it doesn't apply.
All right.
And one last thing, and I couldn't agree with the court more. The records from the South Shore Elder Services, they simply weren't relied on in this decision. And whether they should have been expunged by the court or by the Elder Services, I got them by subpoena. Notice was given to everyone. They knew the records were going to be produced. And ultimately, the most important point is Judge Moriarty didn't rely on, the probate court didn't rely on anything from the South Shore Elder Services.
All right. Seeing no further questions, thank you both for your arguments.
Thank you. Have a good day. And more importantly, a good weekend.
Thank you. Our next case will be 23P498, Stephanie Howard versus David Howard. And I believe we're hearing argument only from the appellee, Stephanie Howard.
Good morning.
Morning.
My name is Angela Stedman. I represent the appellee, Stephanie Howard. I guess my plan for today was to address some of the issues that were raised by the appellant in the brief and in the reply brief that I feel constitute a mischaracterization of the record. And if I could perhaps set the record straight. It has been asserted by the appellant in his briefs that the trial judge did not consider, in reaching her ruling with respect to custody, that she did not adequately consider with whom the children resided in the period of time prior to the judgment of divorce. In that regard, I first would like to point out that primarily the appellant relies on Mass General Law 209C, which is a paternity statute. It has nothing to do with custody in the context of divorce. Other cases that he relied on were in the context of removing children from the Commonwealth, in the context of either paternity or divorce. And while best interest of the child is indeed the standard in those cases, how it is applied when one is removing a child from the Commonwealth is somewhat different. With respect to this issue, I would also like to point out that as a factual assertion made by appellant, he states that the boys resided with father throughout the litigation, and the judge, so he alleges, did not adequately consider this alleged fact. That is not the facts as were introduced into evidence at the time of trial. Indeed, it was undisputed at trial that the boys, during the pendency of the case, which started in early 2019, spent time with both parents. It was only after, in February, early February of 2022, when father was released from his period of incarceration in connection with a complaint for contempt that had been filed, that the boys became angry and very hostile towards mother, and it was at that point that the boys moved in with father. So we're talking a 3-month period of time from February to January that the boys resided with the father.
The father takes strong issue with the judge's finding that he offered no testimony that he found the behavior of the boys. Can you address that? I mean, did the judge just get it wrong?
No, she did not. The judge did not get it wrong. And a brief review of the record could lead one to inaccurately reach the conclusion that has been asserted by the husband. What happened is the husband, father, was brought to the stand. He was cross-examined first. There was a direct examination by his own counsel. There was a recross. And during that period of time, the issue was raised regarding the boys' behavior during the period of time around the father's release from his incarceration. Nowhere in that testimony did father express any concerns regarding the boys.
Transcript page sites?
Pardon me?
Transcript page sites, or this was in recross of the father?
It was nowhere in his testimony do you see him expressing any concern. But
Was there discussion of those incidents?
Later.
No, but during his direct and
Yes.
cross, during his testimony, was there discussion of those incidents and some natural opportunity when, if he really objected to the boys' conduct, he would have said so?
Yes, Your Honor. But even more to the point, I will get the site. Even more to the point, Your Honor, at the end of his testimony is over. At the end of his testimony, there's colloquy between the counsel and the parties, and during that colloquy, the judge expressed deep concern about the boys' behavior and where they were at emotionally, and whether it might be appropriate perhaps to place them in the house of an extended family member for a period of time. The judge specifically stated, volume 2 of the record appendix, page 529, she specifically stated that she was nonplussed by the fact that she'd been watching husband, father, and she was nonplussed by how unaffected he was by testimony regarding the boy's behavior, which is very extreme behavior during this period of time. It was only at that point, that we see father at that point making a comment that the boy's behavior was not what it should have been.
All right, so he did say something.
But only after she said, you're not concerned about this behavior.
If that's what the judge meant,
yes, exactly.
and then maybe the judge should have said, or it would have been better to say, he didn't express any disapproval until he was specifically asked, or until I observed that he didn't seem to disapprove.
Until I told him that the fact that he hasn't expressed that is of concern. And I think, Your Honor, I think the reason she used the phrase "didn't testify" is his formal testimony was over. It was completely done at that point of time, and the statement was made by him in the context of colloquy, primarily between counsel and the judge, and it was at that point he was permitted to speak. So it may have been kind of inartfully stated, but I would say that her assertion in that regard is accurate.
What about the 2021 income? She notes in 3 places, I think, that he said he had no idea what he earned in 2021, and he did give some pretty detailed testimony about that. Hard to follow, admittedly, unless one is familiar with negative pass-throughs, but she imputes a lot of income to him, $165,000 a year, based in part on, I think, a conclusion that he made more in 2021 than he was owning up to, or that he claims he didn't know, but that wasn't credible. So what about that?
That is, so that we find that dialogue at page 430 of Volume 2 of the Record Appendix. We see the start of that colloquy, and it's between the judge and the husband, and clearly the judge is trying to understand what income is for the purpose of calculating child support.
And he says, I had $47,000 in income in 2021.
And then, but that doesn't answer she needs a number for child support, and taxable income is not necessarily consistent with how we use income in the context of calculating child support. So she's trying to determine, he's saying at one point, well, it may be rental income, and that, you know, we've got depreciation that may have been backed out if we are considering rental income. That $35,000 delta may include health insurance. It may include the difference between the starting bank account balance and the ending bank account balance, but one can't. She kept asking him, I need to know what you brought in as income that you can use to spend. And what he says at that point, if you look closely, she asked him specifically in this stretch of dialogue, where do you get that number, 47,000? Because it's clear he doesn't know what the number is. Where did you get the number? And he said, well, I've got a piece of paper prepared by my CPA.
Well, he says, the judge says, where, you know, $12,500 in W-2 income,
Yep.
and where do the other $34,515 come from? It's made up of, the father answers to the husband, made up of K-1 pass-through income, health insurance, forget what else goes into pass-through income. I mean, it seems clear he was offering information about his 2021 income, and yet the judge says he had no idea.
But
so
a couple pages.
did she properly focus on, at least, I mean, she wasn't obligated to credit his testimony, but shouldn't she at least have taken it into account?
If a couple pages after the dialogue you just read, Your Honor, you will see she asked him, where did you, because it was clear he didn't know what that number was, where did you get that number? And he had a piece of paper that created by his CPA, not introduced into evidence, not produced to a trial counsel, opposing trial counsel prior to the time he's on the stand, and he says, this is where I got the number. He doesn't know what that number is. He has no idea. He got it from a piece of paper, a non-exhibit. That's where he got the number. And if we take that fact, in addition to the fact that we have his January of 2022 financial statement at Record Appendix 1, 576, and his October of 2021 financial statement at Record Appendix 1, 563, and we see in October of 2021, he files a signed financial statement with the court reflecting that he's got a year-to-date income of $68,000 and anticipated yearly income in 2021, this is what he's saying in October, of $82,000. Completely inconsistent. And then a couple months later, in January of 2022, he files a signed financial statement with the court saying that his 2021 income was $56,300. Inconsistent with the October financial statement, inconsistent with his trial testimony. It's fair and reasonable to conclude that either he is intentionally misleading the court with respect to his income in 2021, or he has no idea. Either way, the judge's conclusion that his testimony regarding income should be discredited is certainly supported by the record, and her testimony that he didn't know what he earned in 2021, or that he said he didn't know, he said, what he said in that dialogue with the judge was that I got the number from this piece of paper that my CPA, he didn't know. He couldn't explain it to the judge.
So it's one thing to sort of discredit the testimony for all of those reasons that you're bringing up, but to come to the attribution of income, can you walk us through how we affirm that particular determination?
Sure. I mean, we know that the case law is clear that, I guess there's two lines of cases that I'm relying on, but the first is that the case law is clear that when a trial judge is attributing income, she can look to what he has earned in earlier years as a guide to what he could be or should be earning now. And we know that...
But his circumstances are very different, right? Being an employee and then having his own business.
He earned $230,000 approximately as a self-employed business owner for Clarity Engineering, his company, in 2017 and 2018. And in 2019, the year he was served with a divorce complaint, it drops to $190,000. So we've got 2017, 18, and 19 where he's either above $200,000 in income or just below. And I think the judge, in picking the $165,000 number, was more than fair to husband, because his historical income was significantly more than that.
Did she take into consideration the COVID argument and how that impacted his business as well as everyone?
I don't think we see in her decision any comments specifically about how COVID
She says she specifically didn't credit his testimony.
Right.
The court does not credit that husband lost income as a result of COVID.
And we certainly know that, I mean, what he is claiming is that as of 2022, when he files his trial financial statement and he's earning $36,000, the impact of COVID has now gone away for virtually everyone, and he's claiming, on the one hand, that he hasn't gone back to work at a company like Raytheon, where he was employed before he opened Clarity Engineering, because his prospect of his income is returning. And we know we're in 2020, the trial is May of 2022, that his income should be up, but his financial statement with his, the least amount of reported income is May of 2022. None of it makes sense, and I've cited the cases in my brief that where a self-employed person fails to produce the appropriate documentation to establish income, that it is fair for the trial judge to infer that, draw an adverse inference that those documents would have reported more income. Admittedly, the trial judge is, and the cases acknowledge that I cite, the trial judge is put in an extraordinarily difficult position when the person who's coming in to tell you they have no income, who has all the documents to establish that he has no income, doesn't produce the documents.
If the judge had credited his testimony that he had very little income or no additional income as a result of his own business, what impact would the rest of his property have had? He owned additional properties, is that right?
Yes, he owns a rental property up in Maine, which consistently on past income tax returns, it seems like the income and expenses roughly equal out. I mean, I think he depreciates that property, and he may take advantage of that depreciation. But this isn't a big commercial property up in Maine. I think it's a cabin or a residential property that he rents out. So there's not a lot of income coming from this Maine property.
Would there be an obligation to convert that, to sell and convert that in order to meet his obligations?
Oh, I mean, certainly, that there's, as we point out, there's been multiple complaints for contempt because he claims to be unable to pay any of these child support obligations while he's, meeting other obligations, and he had the main property. He had, by the time of trial, the marital property was his. He had refinanced. He had purchased the marital home by the time of trial. Property division was not an issue with respect to that property. He purchased it, so somehow he was able to convince a bank that his income was adequate to refinance that property, and certainly he could have and should have pulled out funds at that point in time to pay his child support obligation, which is the obligation that one obligation that he's actually in arrears on.
So those would have been appropriate considerations for the judge in terms of determining what his actual...
Yeah, I mean, I think the answer is yes. I don't, the issue, I think, before us today is the child support that the judge ordered, and not the contempt that was issued as a result of his failure to pay child support. I don't believe that issue is before the court, Your Honor.
So hypothetically, if we were to remand for additional findings on the 2021 income, because the judge said no idea and it's not, maybe not clear what she took into account, would the judge be able to take into account his 2022 and 2023 income as well in determining child support, at least going forward? And I guess second part of the question, what would that do to the arrears? I mean, could she lower it retroactively, or is that impermissible? If she decided that was what the evidence warranted.
So the question is, I think the arrears have been established conclusively, and what I'm not recalling now is whether the contempt went to judgment, but I do know the arrears aren't before the court now, so I don't think the arrears can be readdressed. I think the arrears are what they're, it's final.
So just prospectively, if we were hypothetically to remand, could the judge take into account not only 2021, but whatever evidence might be produced for 22 and 23?
So if the judgment entered in May of 2022, I guess what I struggle with, Your Honor, is when income goes up or down post-judgment, typically that is addressed with a motion for a complaint for modification. I've never seen that addressed in the context of a remand on appeal, but I've not looked up the case law. But as a I guess
that would be a material change in circumstances standard?
Yeah, exactly.
Whereas if we, okay, versus a remand, if you were free to consider it, there would be no need to show material change in circumstances.
Right, exactly. So that would be the distinction. But I would urge Your Honor to not remand, because I think if you go forward a couple pages from the pages you were pointing out to me, you will see that when asked where he got the $47,000 number, and we do know that 12,500 wages, he seemed firm on that, but where he got that, the 47,000 number, the total number, he said from the CPA, from the piece of paper. He didn't know where that number came from. I think the judge's conclusion was correct.
All right. Seeing no further questions, thank you for your argument.
Thank you.
And our final case for the day will be number 23P489, EW versus MW. And we're going to take a break before that to allow the Zoom to be set up because EW is participating remotely. So we'll take a 5-minute break or so, and when we're set up to go, we'll hear that argument.
Court, all rise, please.
Go ahead.
can see you now.
Okay, I think we've determined what the issue is. Can you hear me now?
I can hear you. Now I can see you. Yes.
Okay. Would you mind going to the bench and just checking from the mics at the bench?
Test. Test.
Were you able to see the tester
Test.
from the bench as well?
Yes.
Okay, so I think we're all set. You're hearing us, we're hearing you, and we're seeing each other. So we're in the middle of a recess, and when that's over in a few minutes, then we'll get started. In the meantime, I would advise just muting your microphone, if that's okay.
Muting my microphone. Sure.
Okay, thank you very much.
Court is now in session. Please be seated.
All right, thank you for your patience. Our final case for the day is number 23P489, EW versus MW. This is a partially impounded case, so I would ask the parties not to use names and just refer to the appellant and the appellee, or other terms that don't identify the parties. All right. So with that, we'll hear from the appellant, MW. You can just say EW, that's fine.
I asked for some patience. I didn't know the case was partially impounded, so I do have some names, so I will work very hard to.
It's the names of the parties that are impounded,
Right.
not names of others.
Right. Good afternoon, panel, and may it please the court, I'm representing myself. I could not afford an attorney, so I ask for the court's patience and understanding as I attempt to present my argument and petition the court to vacate the lower court's ruling that I see as a serious injustice. As a former police officer and state corrections officer, I do not take this statement lightly, as I do respect the laws of the Commonwealth and the courts. However, because of the good work of this appeals court and the Massachusetts Supreme Judicial Court, I do know that lower courts, and indeed all courts, can sometimes err in their rulings. As time is limited, I will be as brief as possible as to allow for your questions. I fully understand the importance of oral arguments and opinions made by this court, and that the decisions you will make with respect to this case will not just affect me and the other party. As you can imagine, this is a heavy burden for someone who is not an attorney. That said, I will do my best and appreciate your understanding and patience. For a party to obtain a restraining order under the state's 209A law, the court must make a finding of abuse. Abuse is defined as attempting to cause or causing physical harm, placing another in fear of imminent, serious physical harm, or causing another to engage in involuntary sexual relations. In the case before you today, there is no claim in the record of attempted or actual physical contact, so I will focus on fear of imminent physical harm. In Amila versus Aslan, the court stated that when a person seeks to prove abuse by fear of imminent, serious physical harm, our cases have required in addition that the fear be reasonable. In a recent case decided by this court, LO v. Gio, the court vacated a 209A restraining order on the grounds the plaintiff, the wife, was not in reasonable fear of imminent, serious physical abuse by her husband. In that case, the wife alleged the defendant showed up at an event she attended her daughter's school event knowing the wife did not want to see him, that he harassed her by way of multiple text messages, and in addition, calling her 72 times in 8 hours. She also alleged the husband blocked her from leaving the bathroom on several occasions in the past and stated she was afraid his behaviors would escalate. As in my case, there is no claim of physical violence or threat of physical violence. And EW makes many of the same and similar complaints and allegations. The court found that while the wife's evidence showed that the husband engaged in annoying and even harassing behavior, such behavior did not provide a reasonable basis to believe that the husband would physically harm the wife or that such harm was imminent. The court noted that events that took place did not involve any physical or visual contact between the parties. The same holds true in my case, Your Honors. The court stated, a statement that the plaintiff is scared is not sufficient. The fear must be objectively reasonable in light of the facts adduced. Your Honors, in the case before you today, EW reaches back weeks, months, and even years before the ex parte hearing and the 10-day hearing to establish her claim of fear of imminent, serious physical harm. She claims no physical harm or attempted physical harm, no forced sexual relations, and her only claim of direct physical threat to her person is that I mentioned the word war in email. When questioned at the 10-day hearing, she admitted I had used it asking that she stop the war that she was waging against me. She also put forth a public records request I made to her employer, one email with no threats whatsoever that I sent to her direct supervisor at Mass Bay Community College in 2019 that who she told me she had an affair with. She complained of annoying emails and that I threatened to publicly shame her for being a bad mother, among other complaints, none of which are illegal or grounds for a restraining order. And per the record, Your Honors, I had not spoken to her in 3 years when she filed. However, we recently had been at school events together, and I was routinely at her home over the years without one negative interaction. It is clear to me, Your Honors, that this restraining order was filed due to the public information request that I had filed. As this court found in LOVGO, even if my behavior and actions were annoying and even harassing, and I am not conceding they were, such behavior does not provide a reasonable basis to conclude Mr. was in physical danger from me or that it would create reasonable fear of imminent serious physical harm. And to be clear, Your Honors, I was not seeking to reconnect romantically as I explained in the record. I was simply offering olive branches and seeking to reestablish a positive co-parenting relationship for the good of my children, as my current wife testified to in the record. In light of this and the lower court judge's actions as outlined in my brief, I ask the court to vacate both orders and direct that entries into state databases be removed. Thank you for your consideration, Your Honors.
So you've presented your case very well. You've presented your side of the evidence. The judge heard EW's side of the evidence as well, including some statements that she feels very afraid and threatened by you and your pursuit of a relationship with her, that you had told her family you still loved her and that she was your soulmate. She feels like this is the type of situation that if you can't have her, no one will. She had no doubt that you will harm her. The judge was faced with the need to decide who to believe. And the judge saw both of you testify, which, we're not hearing today. I mean, we're hearing what the record said, but we're not hearing your testimony under oath. We're not able to judge credibility and things like that. What do we do with the fact that the judge, after hearing both parties for quite some time, over an hour, according to the transcript, decided that he believed EW?
Your Honor, I believe those of you hearing this today are very astute jurists, right? And you've read the transcript. It is clear, it could be clear to anyone that the judge did not allow me to present all evidence. I asked, and numerous times he told me no. This is a case where there was no physical face-to-face discussions, no physical contact. So all the allegations are by email or what EW believes to be the case. So the only way for me to defend myself...
Just let me interrupt you for a second, and whether what she believed was reasonable.
Correct. The only way for me to present a defense against that were the emails that I had, and you read in the record, Your Honors, that the judge told me he did not want to see the emails.
Well, I'm not sure that's true. He didn't want to hear you read an email or perhaps a letter it was written by your son, and
That was one instance, yes.
there were some other instances where it appeared that what was being offered in the emails would have been hearsay, and he kept that out. And I think at some point, any judge has the authority to decide, I'm not hearing anything new in this evidence. What is being offered is cumulative of the statements that I've heard before. So is there any specific instance in the transcript you can point to where something that was critical and not cumulative and admissible was kept out by the judge?
Your Honor, there are so many, and it's clear in the record. When I was examining EW, I asked her point blank, have I hit you? And as you can see in the record, she would not answer the question. So I asked the judge for help.
There's no evidence that you did, and she never said that you did.
Right, but I'm trying to give an example of what happened throughout that entire hearing. She makes a claim. Now, anyone can make any claim, and she made many. And I dispute every single one of them. So I took my time to get emails between the two of us that I could have presented as evidence to refute each one of those, and the record is clear. The judge did not allow me. He said, I don't want to see any more emails. And I told him in the record, I said, Your Honor, this is how I'm going to defend myself. So I feel like I wasn't given the opportunity to put all evidence forward to defend myself. Secondly, again, and Your Honors know this, anyone can make any claim. I can't control.
She never claimed that you hit her, did she?
She claimed that I'm seeking out a relationship with her. She claimed that her family was afraid of me, and I have emails showing that that was not the case. I showed a picture of her brother a couple of weeks prior with his arms around me smiling at my birthday party. I believe that EW understands what she has to say because as a former police officer, in the past she told me she would know what to say. So the only way for me to defend about that is show evidence. I didn't want to give the judge my opinion. I wanted to show him hard evidence.
Can you point to a particular place in the transcript where the judge kept out evidence that you think could have made a difference here?
If you'll allow me a moment, Your Honor. I apologize for the delay.
It's all right.
Under direct examination, there's many examples, it's hard to find right now, but under direct examination, question to EW, are you familiar with the state's 209A law? The judge interjected, and he stated, all right, so get to the point. Of course she's familiar. She filed one. I stated, Your Honor, I'm asking her because in her own words, in her current affidavit, she does not meet any of the elements. I'd like to point that out, Your Honor, as part of my defense. He interjected or responded, that's part of your argument. Now you're questioning her. Right, but my defense is, Your Honor, I want you to ask her factual issues, not legal issues.
Right.
That's for me to decide.
So the judge understood that you were arguing that, clearly, that she had not alleged reasonable fear of imminent serious physical harm.
Your Honor, when you go through the transcript, I know you've already read it. When you go through the transcript, the reason I started with that is because I wanted to take each one at a time and show the evidence she put forward. I had emails to dispute what she is saying.
Well,
again, this is very hard to dispute someone who says that you love them if you don't. I do love her in the sense that she's the mother of my children. We were together for over 20 years. I don't know what kind of person I would be if I had hatred towards her. But this is not what was going on here. I was trying to reestablish a co-parenting relationship because my children told me it was hurting them. You see in the transcript that my son had emailed two of us that morning. So she had the email and I had the email. It wasn't hearsay. He sent it to both of us. And he said this has basically destroyed his life, this fighting. He had told me that for a long time. I apologize because that's a very emotional point for me.
Take your time.
Both of my children have told me how upsetting this is to them. And I don't think it's fair. I've missed 3 years of their life because of these restraining orders. And as a former police officer, had I threatened her life, had I hit her, had I attempted to hurt her, I would have absolutely no problem. I would never be here today. The problem is, she told me in the past that if I contacted her school and let them know she had an affair, she would file a restraining order against me. And I told her, the court will not give you a restraining order if I tell someone that you had an affair. I told the judge that in the first restraining order. I gave him the email as evidence. That's why I filed complaints against him with the ethics committee. I have done nothing to deserve this restraining order. And it's taken 3 years, basically, away with my children. And you have no defense against something when someone says things about you that is just their opinion. In court, you have no defense to fight against that.
Is this something, I mean, this restraining order was issued by the Probate and Family Court. I assume that there was a divorce and custody determination made.
Yes, Your Honor.
I assume that the custody orders of the court are being abided by.
No, Your Honor, because we had joint custody. I could pick up my children whenever I wanted. They could call me and say, Pops, come pick me up. But because of this restraining order, I'm allowed to pick them up once a week. His school events, I've missed his school events. I've missed his sports events. The reason that I was pursuing EW in the manner that I was, and I had emails to show the court, but he would not, and the record shows he would not let me show them. I asked her time and time again, please, just meet me halfway for drop-up and pick-up. Tell me about his school events. Tell me about his sports events. Let me know if he's sick, and that was it. And in fact, in the record, it shows that I had EW read to the court where it says in the email, I do not love you. I am not seeking to reestablish a relationship with you. I am only asking you to reestablish a co-parenting relationship. It says it right in the record, Your Honor.
No, we saw that. I would just wonder out loud whether, if there are issues with the how the parties are complying or not complying with the custody orders of the probate court, or whether there's more that could be done to ensure a cooperation without undue contact. And I saw there was a mention of one of those apps that allows parents to communicate without raising issues about contact. I just would wonder whether that is something that could be raised in the course of the complaint for modification or otherwise in the divorce case rather than through the 209A process. But
right. Your Honor,
I'm
but
not
again,
familiar with the status of that, so obviously
right.
we're not in a position to get
But I'm
to
here
it.
testifying, Your Honor, to tell you there was no court order pertaining visitation with the children when we got divorced. When we went in for a divorce, we were actually going to stand at the same table because we were trying to work together at that point. Since then, the relationship has gone wrong, and I have a part to play in that. I did send the man that she told me she had an affair with, I did send him an email. And the next court day available, she was at the court asking for a restraining order. So to her word, she did what she said she was going to do. And the relationship completely fell apart after that. Now, obviously, in a divorce, it can be rough. But I recognize the pain it's causing to my children. So at this point, I was trying to reestablish a co-parenting relationship. My former wife, who you saw the testimony in the record, Your Honor, she encouraged me to reach out to EW to reestablish that relationship, as she had done with her former husband. So I was trying to do what I could. And because it had, since 2019, she refused to talk to me because I sent that email to that man. It was a gigantic struggle to try to get her to understand that I'm not looking to establish a romantic relationship with you. Let's just be able to say, hey, I'm picking my son up at 6,
We see that in the record, in the transcript of the hearing. here,
Right.
so.
Your Honor, I feel these restraining orders are very important. I helped many women get these restraining orders. In almost every case, there was threats of violence, physical violence. I've been in houses where kitchen tables have been flipped over, people are bleeding, and I understand that you can threaten someone and not touch them. But in the record you see, EW does not give one instance of me saying, I'm going to come and hurt you. I'm going to do this to you. I did say I would shame her publicly, come to her work and stand on a public sidewalk. I said that in a moment of anger, and I never did it. I haven't been to her work in 10 years.
We've got your argument. You've presented it very capably, and I think now we need to hear from EW.
Thank you, Your Honor.
Thank you. So we will hear from EW now.
Hi there, thank you for your time. I am requesting for this to continue, the restraining order to continue. I don't know if I need to share what has happened in the past. I requested this for a second time. My initial one started in 2019 and again in 2022. I'm requesting this because of the threatening nature of his email communication and the escalation of his intimidating behavior to control and pursue a relationship with me. I have provided much evidence regarding MW's history of having a restraining order from other people in the past in high school. He also has mental health issues where he has stayed in the past clinical settings for weeks at a time. He's had electroconvulsive shock therapy and has been under the assistance and guidance.
Let's keep it to the facts that are, or the evidence that's in the record, okay?
Okay. I believe that I've proven, and he has stated in his testimony that he does have some mental health challenges. In the evidence that I provided, he has been under the care of a clinician and has stated that he does understand he has PTSD, worked with a licensed counselor, and he's made references in his testimony as well as in the evidence that I provided about having some panic attacks, but he mentions having tests in regards to feeling faint and relating to his heart. MW has also stated that he has excessively emailed me, and his, I'm sorry, I'm really just very nervous. And his escalations of feelings for me throughout his emails over a time have escalated from asking me to meet him for drinks, meet him to have a relationship, meet him for his birthday party, sit down and talk with him. And when I would not respond in the evidence I've provided, it showed that, okay, now I'm going to do this, now I'm going to do this, now I'm going to do this, and it escalated. And I provided so much evidence. I provided,
Can I interrupt for a moment?
Sure, I'm sorry.
And so we are constrained, if you will, in reviewing the record of the hearings, and I think it was a lengthy hearing in which there was an opportunity for both sides to present their version of events. And it appears to me that underlying this action was definitely a feeling that you were being harassed, that the continual contact and invitations and emails and behavior constituted harassment. What I'm a little bit unclear of is, and I want to understand from your testimony in the prior proceedings, how the harassment then equates to a fear of imminent bodily harm.
Okay. with the escalation of scary behavior and prior history of mental health, in 2019, part of that mental health was he sent letters to my work as if at the time, I believe my son was like 8 years old, as if my son sent letters to my work. Truly believes that I had an affair and even states that I have stated I've had an affair with a gentleman from my employment. And I never have, I've never just, said that I've had. And with this particular case, with his emails, he mentions being triggered by me. He mentions feelings of war. In my personal perception of war, someone is going to get hurt and there will be harm to a person. He would come to my house when my children were not here and knock on the door. He would send in my children to request that I come out and speak with him.
May I interrupt briefly to ask?
Yes.
Is that in the transcript anywhere that he came to your house when the children were not there?
He, not specifically, he said I never banged on the door. And I had stated, but that's not true. And I believe I was asked to stop my testimony because he was speaking at that time. So I was going to get into that, but I didn't. It's just not true. In some of his emails to me, oh, I'm sorry.
No, go ahead.
In some of his emails, he was sharing information about his current relationship with his wife, letting me know that he was separated, sharing his Match.com profile with me, letting me know he was talking to someone at my work that works there, constantly making reference to many men that I am with, that he wants to meet these men. That he will help me with these friends, constantly asking me to meet him. And his relationship with his wife, he did state that she is spying on me, that he has doesn't trust her, and that she was spying on others. That's in the transcript. But the lots of references about being at war and his bizarre behavior ramping up in regards to starting like oh hi, sorry, I know I'm not supposed to say that. Hi EW, and then contact me EW, and then when I don't contact him, okay, this is what's gonna, you forced me to do this EW, you've gone to do this, and mentions war so many times, along with we're at each other's throats. I don't want to have to shame you. I don't want to have this happen next. You're forcing me to do these things. I can't force you to have a relationship with me. Blah, blah, blah. All these things is scary, bizarre, along with mental health. He was, and MW has stated that he was a police officer. He does know how to use guns and weapons, and he does have land in another state. I don't know if he can get weapons in other states as well. He has left his position as a police officer after a year of being employed due to mental health issues and some stays that he has had in terms of mental health facilities. I am very concerned. I truly feel as though if this is not in place, I will be harmed by this man. And I truly feel like this is a case where if he cannot have me, no one else will. In addition to that, I think we draw a line, and he likes to go right up to the line to see what he can do. For example, just even trying to deny my request of being in person today.
Yeah.
Of this.
Let's keep the, your argument to the, what's evidence in the record, okay?
Okay.
Thank you. But go ahead, you can continue. I just don't want to get into interactions that are outside the record.
The constant threats of him stating that he is at war, I will not win, and the intimidating behavior is absolutely, along with telling my family that he still loves me, telling me that his wife thinks that he's still in love with me. One particular case that he had my son, and he brought this up in his testimony, is about how I wasn't responding to his emails, and he wanted a response. So one day he emailed me saying that my son was sick. He was having an anaphylactic, he was having a rash and some skin things on his face, and he thought that he was sick. I needed to contact him. He's done this in the past, so I did not. And another one, I can't believe you're not calling right away. Your son is sick. And then he states he's at the emergency room with my son. I didn't believe him because he sent pictures, and I didn't believe that the pictures looked like anything. My kids are very fair. The next day, he writes me a disparaging email saying, I'm the worst mom. How did I know that he didn't go to the ER? His kid is fine, luckily, blah, blah, blah. So these little acts of him doing things, and bizarre that sometimes he's with my children, this particular time with my youngest, to get my attention is extremely concerning to me.
I don't think the panel has further questions for you. You do have some time left, but if you've said what you want to say, you don't need to use up all your time. You're all set?
I believe that the last two restraining orders were put in place in regards to the evidence that I've provided and produced in those lower courts. Plenty of evidence beyond just harassment, but I am in imminent fear of being in the vicinity of this person. And I do fear that if this does not continue, I will be in danger. That is all I want to say.
All right, thank you. Thank you to both parties. You've both done a very good job of representing your positions. And with that, we'll take the case under advisement, and that concludes our session for today. I want to thank our court clerk, our court officers, and all the court staff for their assistance. And with that, we are adjourned.
All rise, please.